short. Try not to get here earlier than 1:30 if you are arguing. That way we could accommodate everyone safely. That's it. Have a good day. Thank you. Please rise. The justices of the Appellate Division, Supreme Court, First Department. Hearing, all persons having business with the Appellate Division. Drawn here, in attendance, and you shall be heard. Please be seated.
Good afternoon, and welcome to the Appellate Division, First Department. You all know our typical shtick at the beginning of each calendar call. Please ask for the time that you need, not the time that you want, as we have 6.5 hours of requested argument time. People versus Sergio Rodriguez.
Appellate requests 7 minutes plus 1 for rebuttal. Mayor Stein requests 7 minutes.
5 and 2 and 5. HMC Assets versus Schrick.
Appellate requests 7 minutes and 2 minutes for a vote.
Okay, it looks like you're arguing alone. Do you still wish to argue?
Please the court, yes, ma'am.
Okay, I'll give you 4 minutes. P. Children is submitted. Ortiz Zayas versus 98 Rivington Realty. Are you here for?
I'm a plaintiff respondent.
Okay, the defendant has called, said that they are running into delays. They are on their way, but they wish to argue. So I'm going to grant time. I'll call the case in the regular order, see if they have arrived. If so, we'll take the case. If not, we'll have to wait until they arrive, okay? Okay, so I'm going to give you 4 and 2 and 4 to the other side. Okay, and we'll wait.
And 2 respondents. There's 2 respondents.
Oh, there's 2 respondents.
98 Rivington's also answering the call.
Okay, so.
And I'll request 3 minutes.
3 minutes. Okay, 4 and 2, 3 and 4. Okay?
Thank you.
All right, thank you. Borgella versus City of New York. 5 and 2 and 5 and 6. Mancusi versus Avalon Bay Communities. Okay, appellant. All right. You still wish to argue? 3 minutes. You got it. People v. Stewart is submitted. Ashanti versus New York City conflicts. Okay, 5 and 2 and 4. Coster Brady versus Kalan. Granted, 5 and 2 and 5. DeFelix versus 590 East Fordham Road. Again, we received a call from the court. You're here for? Okay, and your adversary is on their way, so 4 and 1 and 3. People v. Renee Garcia is submitted. Basderick versus Alma Partners. Okay, how much time would you like? Wonderful, thank you. Submitted. SL Globetrotter versus Savretta Capital. All right, 6 and 2 and 6. People v. Fatir Bowie. I'm sorry? Oh, yes, Cortez. Thank you. Cortez versus Terrence Cardinal Cook. Okay. Okay, 6 and 2 and 5. People v. Fatir Bowie. Submit. Kokak versus Dargan. Okay, 6 and 2 and 6. Judge Moulton, how do you pronounce this again? McCachran versus Extel Development. Thank you. 4 and 2. 4 and 2.
Respondent requests 3 minutes.
3, thank you. NRZ Pass-Through versus Rouge is submit. Carras versus George Comfort and Sons is submit. First case on the calendar, People versus Sergio Rodriguez. Counsel. I was like looking at it.
Good afternoon, Your Honors.
Good afternoon.
Claudia Troop on behalf of Sergio Rodriguez. This is a very unusual case in which the court has before it a sufficiency and a weight of the evidence argument in which there is really no dispute about the facts. Both sides agree that the single witness to this encounter, Trevor Englund, was a credible and disinterested witness. And so the only issue before the court that I'll be arguing today is whether the prosecution disproves beyond a reasonable doubt Mr. Rodriguez's justification defense. And a review of the record reveals that they did not do so and that this conviction should be vacated and the indictment dismissed. So I'd like to begin with the beginning of the encounter when the deceased came into the room, turned on the lights, disturbed the entire dorm, and when Mr. Rodriguez complained, approached Mr. Rodriguez in an aggressive manner. Mr. Englund put himself at the shelter employee.
Counsel, there was a third roommate, correct? Mr. Dorino.
There was Mr. Dorino, who it is, all sides agree, did not see the entire encounter.
He did hear Mr. Velez say, "You stabbed me."
Yes, and there's no dispute that Mr. Rodriguez stabbed Mr. Velez. The issue here is whether or not the prosecution disproved the justification defense beyond a reasonable doubt. And so from the beginning of the encounter, Mr. Velez was acting in a very aggressive manner, invading Mr. Rodriguez's sleeping space, throwing the first punch. And when Mr. Rodriguez fought back, eventually gripping Mr. Rodriguez by the neck. I would ask your honors to review pages 251 of the transcript in which Mr. Englund testifies that the grip on Mr. Rodriguez's neck was really strong, and it was so violent that he heard the sound of Mr. Velez's hand on Mr. Rodriguez's neck. And he then said that Mr. Rodriguez's expression changed as the hand remained on his neck. And Mr. Rodriguez, at page 253, tried unsuccessfully to dislodge the hand on his neck, but he could not get the hand off of his neck. At that point, Mr. Rodriguez stabbed the complainant, and in order to dislodge the hand on his neck, and once that was done, no further force was used. The prosecution's response to these arguments about the justification defense are that the defense was not supported because Mr. Rodriguez did not tell the police or testify at trial that his actions were justified. But those types of arguments at page 21 of the respondent's briefs are direct comments on Mr. Rodriguez's decision to remain silent. Those would not be appropriate at trial, and they are not appropriate on appeal where we're asking your honors to serve as the 13th juror.
Counsel, were there any marks on his neck?
There were no marks on his neck when he was
Did
arrested.
anyone claim that he couldn't breathe?
He said the testimony was that he was struggling to dislodge the hand on his neck.
I'm just talking about taking the hand. He didn't want the hand on him, right? We all agree on that, but there's no testimony that he couldn't breathe. There's no marks on his neck. He has only one hand, right? Not both hands, just one hand.
Yeah, Your Honor is correct.
So with all of that, you're saying the jury couldn't have found that his justification of stabbing the victim was not proven?
No,
you're saying
because
all of that doesn't...
No, because as the law is in the state, you don't have to wait until you can't breathe or till you're passing out. It's the imminent use of deadly force. And here, a hand on the neck.
But why was the jury not entitled to reach the conclusion they reached based on the facts that my colleague just pointed to, added to the fact that if indeed your client had felt justified in his behavior, he certainly didn't demonstrate that by staying on the scene and speaking to the police after stabbing him.
Well, Your Honor, he did leave the scene. There's no dispute about that either. But the Court of Appeals has recognized, as has this court, that flight is weak evidence of consciousness of guilt at the most, and that's because people respond to stressful situations in different ways. And Mr. Rodriguez knew he had stabbed somebody. He's not necessarily familiar with the intricacies of New York self-defense law, so he feels he's done something wrong, perhaps, but that doesn't mean that his actions weren't justified. And once again, there doesn't need to be...
Counsel, I have one question. You argue that the testimony was that he stabbed the victim to get the hand off the throat.
Yes, he
But
stabbed...
there's trial testimony that I thought I read that after the defendant struck Velez released his hold on the defendant's throat.
Yes, and there was no further use of force after that.
And then he stabbed him.
No. It was that there was the hand on the throat. He tried to dislodge it. At page 253 of Mr. England's testimony, if you review that portion of the record, the testimony is he was trying unsuccessfully to dislodge the hand from the throat. He could not get his hand off, and it's at that point the deadly force is used to dislodge the hand.
Okay, thank you. You'll have time on rebuttal. Counsel?
Good afternoon, Your Honors. Noreen Stackhouse for the people. The jury heard all of the same arguments the defendant is making on appeal, heard all of the testimony that counsel highlighted today, and still came to the conclusion that the defendant was not justified in stabbing the victim in the heart. First, they knew that the defendant armed himself before he even got out of bed, that the victim was unarmed and had never been aggressive with anyone in the room before. That suggests that the defendant intended to injure the victim before the victim even touched him. The nature of the wound itself is also evidence that defendant intended to seriously injure him. He stabbed him directly in the heart, creating a 4-inch wound and penetrating clothing, skin, muscle, and the heart itself. He also did stab defendant a second time. The testimony that my adversary was referring to was the homeless shelter employee who admittedly only saw one stab, or one punch as he classified it, but the autopsy showed that there was a second stab wound and that it was next to another vital organ. It was next to his kidney. And as Your Honor pointed out, there was no evidence that the victim was actually strangling defendant or squeezing defendant's neck with enough force to create a risk of serious injury or death. There was no testimony that he was gagging, having trouble breathing, that he had trouble talking afterwards. He was pictured on surveillance video yelling at an
Counsel,
employee.
as your adversary pointed out, the law doesn't require someone to be at the point of death before they begin defending themselves.
Of course.
So if somebody is squeezing your neck, don't you have a right to defend yourself?
You have the right, I think, to defend yourself, but if you are not at risk of an imminent serious physical injury or death,
Well,
you do not have the right
how
to
does
stab.
one know that, right? I mean, again, if you wait, is as if as the person being choked, you have to wait until you start feeling woozy, like you're losing consciousness before you react, that might be too late.
The problem is there's no evidence that defendant felt that way. While counsel is right in pointing out that he didn't have to testify, there's still a subjective prong to the self-defense inquiry that was not met here. There were no statements that he felt that his life was in danger, and there was no objective evidence of that
Was
either.
there
Counsel-
any, I'm sorry, go ahead.
Sorry. The presence of Mr. Anglin in the room as well, and Mr. Dorino, would that be something the jury could take into account in evaluating the?
Exactly. There were 5 to 6 men in the room that if they had thought this man is about to die, would have had the opportunity to intervene. Instead, they didn't. And at the end, one of them actually told the defendant that he should get out of there, which shows that they knew that he did something wrong, that he shouldn't have stabbed the victim.
Well, what somebody else thought can't be transferred on to the defendant here.
Of course, and that's just what he also displayed consciousness of guilt by running out of there, even though one of the shelter employees tried to stop him. And that's not the only thing we're relying on. That's just one very piece of the mosaic of the evidence.
Okay,
If you have no
Thank
further
you.
questions, I'll ask you to affirm. Thank you very much.
thank you. Counsel?
With respect to the question of Mr. Anglin being there, and is that something that is relevant for the jury to determine, Mr. Anglin was very clear in his testimony that there was a no-touch policy between the members of the staff and the residents, so that as soon as the fight broke out, Mr. Anglin had originally placed himself with his facing the deceased because the deceased was the aggressor, but once the deceased became so violent, he had to step back pursuant to the policies of the residency. And so the fact that Mr. Anglin was there was not something that Mr. Rodriguez could expect help from because he had already stepped out of the encounter. With respect to whether there was evidence because Mr. Rodriguez did not testify about his subjective belief, there was circumstantial evidence from a disinterested witness. Had Mr. Rodriguez testified, the jury would have been instructed that he was an interested witness as a matter of law, and that he was, he had his own stake in the outcome here. We had something better here. We had a disinterested witness who testified, and the circumstantial evidence of when somebody puts a hand to your throat and you can't remove that hand while you're struggling, that is circumstantial evidence of a subjective component that you would believe that your life was in danger. And for those reasons, we would ask that this court vacate this conviction and reverse the judgment. Thank you.
Thank you. HMC Assets versus Trick.
Good afternoon, Your Honors. Michael Kennedy Carlson, K-A-R-L-S-O-N. For Appellant Robert Trick. My client made a pro se motion originally, motion sequence 1 in this case, to challenge the jurisdiction of this. The first order that came out of that, which was never vacated, Your Honor, was dated February 18th, 2016, which said that if the motion was properly served, there would be a need for a traverse hearing to resolve the jurisdictional question. Later on, they did have a hearing as to that, and also as to whether the motion was properly served. And the court found that despite the testimony of appellant's sister, who apparently, I guess, was the one who testified that she served the motion, that the motion was not received by plaintiff's counsel. I suppose it should have been more a question of whether it was mailed, but be that as it may, the motion was denied for not making a proper motion. At some point later, he retained counsel after, this was now motion sequence 4, with Petroff Amson, and made another motion. At that point, the plaintiff's 2 motions, well, one had been granted unopposed, one was pending, and I guess it was granted before then, but the judge treated the 5015A4 motion as a 5015A1 motion. and said that it was denied for failure to show a reasonable excuse and meritorious defense, but it was clearly labeled as a 5015A4 motion, and so therefore it should have been treated as such, and the jurisdictional issue should have been resolved before that. Also, there was no timely opposition to it. The plaintiff did not put in timely opposition, and so their two motions were granted unopposed, and my client's motion was denied, which was also unopposed. And the prior order from February 18, 2016 was the law of the case, which still extant because nobody appealed from it and nobody asked for it to be vacated, and the judge, neither the order appealed from nor the September 12, 2016 order, in fact, vacated the February 18, 2016 order. That raises a pure question of law as to the effect of that order on this case subsequently. One other point just to make is that the respondent's brief mentioned that the original mortgage was $800,000. It was actually $80,000, which you can see from the documents in the record. If the court has any further questions.
No?
Thank you, Your Honors.
Thank you. Ortiz Zayas versus 98 Rivington Realty. I understand all counsel are present now.
Yes, thank you, Your Honor.
Okay. You may proceed. You have 4 minutes.
Good afternoon, Kathleen Foley for Catherine Daly, appellant. First of all, our arguments here are pretty simple. The special use argument to hold us in fails. This metal platform, first of all, we were only a tenant. We were not the owner of the premises. This metal platform was there long before we started our tenancy and long before the accident.
Who put the game console on that metal platform?
Yes, we did put it on the platform.
Right.
But it did not alter the platform.
Well, no. Let's take it apart one step at a time. So the game console is yours. You're conceding that your client put it there, right?
Correct.
And I believe my understanding of the testimony, the plaintiff's testimony, is that the kids were all hanging around that game console so she couldn't see actually where she was walking, and that's why she tripped and fell.
That's one of her arguments,
That's
yes.
her testimony, right?
Yes.
Okay, so great. So why don't you think that there is a potential liability there?
Okay. As I said, we did not install or we could not change this metal platform. Our
understand.
putting
I'm not
something on
disagreeing with you.
top of it
Yeah.
was merely fortuitous. If that hadn't been there, we would have put it on the sidewalk.
But it was there, and it created an additional item for pedestrians to traverse. So why should you not be held, not you personally, why should your client not be held to account for their contribution to this accident?
We are only the tenant. We had no.
It doesn't matter. You put the item on the sidewalk that produced a crowd that thereby limited the visibility of this metal.
Okay, that is a different argument. And what we're saying is that on that issue is that she admitted this is a very busy main intersection. There's tons of people there. There's people waiting to cross. There's people at the intersection. It would be purely speculative for her to say that she couldn't see because little Johnny was waiting to get his stuffed animal rather than the 4 ladies and their 6 teenagers who are waiting to cross the street.
But
She's never
counsel,
going to be able to.
Isn't that what she testified to? Isn't that what she said? It wasn't that her testimony? That she couldn't see because she put the game there and there were kids around it. That's her testimony. You might not like it. You might not think it's credible, but that certainly raises an issue of fact as to whether or not you caused and created the problem.
My understanding is that she said there were a lot of people there. She couldn't identify that it was the children who were around.
Okay, well,
the
you and I
game.
might disagree. I mean, I read her testimony. I think she said the kids around that game was what caused me not to see the raised
So here's another point then. If that game console was not there, right, she would have had a clear path on that metal platform. Because if the game console was not there and there was a crowd on the corner, as you say there's a lot of people there, she would have just stepped on the metal platform, just traversed it and walked right through. But she couldn't because the game console there and little Johnny was there waiting for his little toy.
Right, but there might have been a crowd of people there. It's just as likely that there would have been people there waiting to get into the deli. That's also
Well,
past
so-
That sounds like speculation on top of speculation.
But I'm saying it's
There
all
may have been
speculation.
people on the sidewalk. We don't decide cases that way, counsel.
Well, right, but isn't it the same, though, to say that those
She
people
testified
wouldn't
there
be
were
there?
children in my way. I could not see the ground and the metal platform. You'll have time on rebuttal.
Thank you.
Good afternoon, Your Honors. Arnold D. Joseph for the plaintiff respondent.
So why couldn't you just push everybody out of the way?
Judge, and I want to add one other thing. Otherwise, I really, unless you had questions for me, they took the position, their witness took the position that he never saw this game on the platform at all. I don't know, the only person that's telling you that they put it there is the attorney. But it was there because it's in the photographs, but the guy that swept every day says it wasn't there. They didn't put on anybody to make out a prima facie case as to what was going on with this game, but want you to just say that I resolved the question of fact in favor of myself, even though I put this on obstruction on the sidewalk, which is within the sidewalk area, and specifically in their lease it says not to do that. So summary judgment in this case, it's not a case for summary judgment. It's an issue of fact. Thank you.
Thank you.
Oh,
Hold on.
Oh, so sorry.
Good afternoon, Christopher Delbove, on behalf of 98 Remington. Based on the oral argument in this case and the record before, we have nothing further to add, and I yield the rest of the time back to the court. Thank you.
Thank you.
My last quick point is that under the special use law, it must be the special use itself that creates the defect. Plaintiff's saying that it's the metal platform that is the special use. The court seems to be saying that it was the machine that was the special use, but the machine itself she didn't trip on the machine. She didn't fall on the machine. She fell on the metal ramp and a metal platform. And that is what they are calling the special use. So that piece of the special use formula simply does not apply here.
Okay,
Thank you so much.
thank you. Borgella versus City of New York.
Good afternoon, Your Honors. Brian Isaac, I represent the plaintiff appellant. I think the issues here are fairly clear, so I'm actually going to try to go under my time. My first point, if you see an object in the roadway, you know it's there, you can't hit it. I think that's what you said in Bunn against the City of New York. I think that's what the Second
yeah, but
Department said.
Mr. Isaac, this is a very interesting situation here. You had firefighters testifying that their lights, sirens, and horns were operational because they were responding to a 911 call. And we all know, just anecdotally, when a fire truck's got their horn blasting, they're blasting that horn, basically saying, get out of the way. So your client's double parked, correct?
Yes.
He's a cab driver. I understand there's a rule that says cab drivers are permitted to double park to discharge or permit and load passengers. Well, when you get a fire truck barreling down the road, get out of the way, right? I mean, so that is a classic credibility issue that the jury had to decide, because your client's saying, I didn't hear, there were no lights and sirens, and fire's saying, yeah, there were lights and sirens. So why should we change the verdict here?
I actually have an answer for that question, Judge Owing. Let me tell you what it is. There is a credibility question. I'm not disagreeing with you. It's a credibility question going to comparative negligence, not going to affirmative negligence. And we know from Rodriguez that comparative negligence is not any longer.
The
a cause.
VTL,
yeah.
that-
I'm sorry, but you can't assume negligence simply because the accident happened. And you can't assume that. So the question then becomes, who's negligent? Is it the person who violates the VTL and doesn't get out of the way when they're supposed to? Or is it the fire truck going down? The jury found it one way.
Well,
Why should we overturn that? There's clearly a credibility issue of
There-
who was negligent.
yes, there are
The jury found that the cab driver was negligent under the VTL, and I don't see how you can get around that.
Well, let's talk about what the driver said. So we know what the driver said. The driver said,
The driver said he was in the car, he wasn't in the car,
Well,
he
I'm not
didn't
even
hear the things, he
yeah.
did hear the things, come on.
I'm not even talking about that. I'm talking about what he said about what he did. He said, I waited behind the car for a minute.
wait a minute,
And-
he was out of the car then? You're
Sorry?
saying that he waited out of the car?
No, he said he waited behind the car.
So he's out of the
Right,
car?
he waited
Mr.
behind the-
Isaac, come
he
on, that means
waited-
he's out of the car, behind, in front,
Yes.
whatever,
He
he's
said
not in the
waited-
car.
And he waited for a minute, and then he went. He also said that this is not an unusual occurrence, that it happens all the time, and that he's
So let
able
me
to
ask
get
you a
around.
question. Hold on a second. Let's just assume that I agree with you. That it's, gets comparative fault. You just said that your client said that he's out of the car.
No, my client said he was in the car. Both of the city witnesses said he was, my client said he was in the car. Both of the
I'm
city
just asking you a
witnesses said he
very
was out of the
simple
car.
question. Where was your client when the car was struck?
He says he was in the car. The city witnesses says he was out of the car. That's what they say. There's no question about it.
So then if he's in the car,
Yes.
you hear lights and sirens and a horn blasting, and we all know those fire trucks, man, when they're coming down, you know they're coming down. He should have moved his car.
I'm not asking for a dismissal of the case as to comparative negligence. What I'm
No,
saying
you're
is that,
asking for a verdict against, you're asking for a finding of fault, finding of negligence, liability against the defendant city, so
Yes.
that we can move on to whether or not plaintiff was comparatively at fault. That's
Correct.
what you're asking for, right?
yes, I'm saying that there is a question of fact as to the plaintiff's comparative negligence, but I'm
But
saying that,
but you have to first get over that hurdle that that we have to agree with you that the defendants were negligent.
yes, that's right. And my position is that based on the Bunn case and based on the Sharpton case, which involves similar situations where you
Those
have.
are rear end collisions, correct?
This is this is a rear-end collision case.
But the other-
Sharpton was a left turn, and Bunn was just a striking.
Were there
of-
lights and sirens involved in those two
No,
cases?
they're not.
That's the big difference. There's an issue here of lights and sirens and horn.
Not under the charge. This is a negligence charge. If you look at the charge,
No,
there's
but
no,
the
there-
court
it's a
did charge-
negligence case. Yes?
The court did give the charges on the three statutes, the two VTLs and the city reg, though.
They did, but there's, it's a straight negligence case. If you look at 165 and 166, it was not charged with any emergency doctrine under 1404.
But again, the fact of the matter is that the jury could have found that the defendants were not, your client was negligent in not moving his car and violating the VTL, and that the fire truck wasn't negligent. That you're asking us to assume because the accident occurred that the defendants were negligent, and that's not what the jury found. And there's plenty of evidence going every which way. So it's a jury verdict.
Well,
you know?
if I can, obviously I need to convince you, you're the ones I need to vote for, but my position is that if you see something in the roadway and you strike it, even if you're trying,
Go
can I
ahead.
finish my answer? And you try to get by, you cannot strike a fixed object. I'll get to my record charge. I won't use up my time afterwards.
No problem.
Good afternoon, Your Honor. Amy McHemphill for the city respondents. Your Honor, the trial court's judgment here, which was based on a jury verdict in favor of the city, should be affirmed. The jury could have found either one of two possible things here. They could have found that the plaintiff was not in the cab at the time of the accident, and the plaintiff's attorney admitted at trial that that would have been a proper basis for a defense verdict. There was lots of evidence to support that
Now,
conclusion.
whether or not he's in the cab, to me, goes to the damages issue, because he's claiming, everything that you can claim for a rear-end collision. So whether, the threshold question is for me is whether or not the defendant is negligent. I mean, you don't even get to damages, because damages then gets down to whether he was in the car or not in the car, right? Because if he's outside of the car, he couldn't have any damages, right? He couldn't have suffered any personal injuries, correct? That's pretty obvious, correct?
Yes, Your Honor,
Well,
and
let's not even go down that road. My only thing is the threshold question, as you heard, is that they're asking for a directed verdict against the city on liability, that you guys are negligent. So what's your response to that?
well, Your Honor, the case of Tobacco versus North Babylon Fire Department is directly on point. It says that when you have an emergency vehicle that's coming down the street and there's a collision and there's a question of fact, either whether the plaintiff complied with the vehicle and traffic law in yielding to the emergency vehicle, the plaintiff is not entitled to a directed verdict on the issue of negligence. And plaintiff fails to address that case in his papers.
That case doesn't stand for the proposition that if a fire truck is coming down the road and someone doesn't yield and get out of the way, that the fire truck has the right to ram their fire truck into the car.
No, Your Honor.
Okay,
But
so the fact that someone doesn't abide by a VTL and quickly enough move out of the way does not absolve the fire department from exercising due care in driving a 2-ton vehicle.
It's a question of fact for the jury under those circumstances when there's a dispute about the plaintiff's compliance with the VTL. It's a question of fact for the jury whether or not the fire truck was driven with reasonable care. And here the jury could have found, based on the evidence, that the fire truck was driven with reasonable care. There's consistent testimony that lights and sirens were on, the horns were blaring, the firefighters testified they pulled up behind the cab, they waited for the cab to move, the cab did not move, and they attempted to carefully drive around it. So the jury could have found, based on that evidence, that the fire truck, under these circumstances, was driven with reasonable care. And for that reason, the judgment should be affirmed.
Okay.
Thank you, Your Honors.
So if I can, in my 2 minutes, let me get to the recharge issue if I can. The jury sent out a note, as you know, at 592, which says, and I'm quoting, "If someone acts in a way that a reasonable person would, but makes an honest mistake, does that count as negligent?" Plaintiff's lawyer read that as saying, can someone be negligent when they make an honest mistake? Let's say that you're going to give me a worse construction on that, and it's actually 2 questions. Question 1 is, can someone be negligent if they act reasonably? And 2, can a party be negligent when they make an honest mistake?
Did trial counsel take an exception to the judge's recharge to the jury?
Yes, he did. He actually said, I want you to answer the question, yes.
Now,
And the judge
after
said no.
the judge gave the charge, the recharge to the jury, after she gave the charge, did he take an exception to that charge?
He didn't, but he wouldn't have
He
to.
did
Under a
not.
case called, I'll give you, there's a case called Gangi against Freitas from the Court of Appeals, which says once you make a position known, and once that position is rejected, making continuous objections at the same time isn't required. And he said it twice, not once, but twice. I want you to do that. Now, I think everybody cites Bender against Nassau County Medical Center as being the lead case on this, but I actually think it's your case. I think Schwabach is directly on point. It's 72 AD 2nd 308, 312, and this is what you said. Quote, when, as in this case, the jury pinpoints their lack of understanding, they are entitled to something more than that which led to their original confusion. That's exactly this case. They should have been instructed on the precise subject upon which they manifested their doubt. So,
but is it unreasonable for a court to, on the very first jury note on an issue, assume that there is such confusion such that simply restating the rule of law applicable to the question would not be appropriate?
our position is under Schwabach and Bender. The answer to that question, Judge Manzanet, would be yes, because they manifested two specific questions, worst case scenario to me. First point, can a person be negligent when they act reasonably? If I was a judge, obviously I'm not, I've never sat on the bench, but the answer to that is no. Question two is, can a person be negligent when they make an honest mistake? And the answer is yes. They were not
But
instructed
Mr.
on
Isaac,
that.
isn't that covered by the charge? The charge, I mean, I gave that charge. We've all given that charge many times.
I'm aware.
Covered straight up by that charge. So those questions were answered by recharging the law. And then there weren't any follow-up questions that saying, no, this isn't enough for us. So the charge tells you whether it's enough to be reasonable. The charge tells you whether a mistake is. So the trial judge did exactly what the Court of Appeals is constantly telling us to do, which is stick to the PJI.
Well, but that's I think the problem with that argument, if I can, Judge Scarpula, is that it ignores the essence of what Schwabach said and what, can I finish? And what Bender said, because I'm not saying the court didn't charge correctly. Obviously, the court gave a correct charge. But even though it gave a correct charge, the jury manifested some confusion and had two specific issues which weren't covered by the charge. So I'm not faulting the trial judge for what the original charge.
You don't think the negligence charge covers reasonable person? I mean, reasonable is in that charge 10,000 times.
It is, but despite the fact that they gave that charge originally, the jury still came back with the question. So if the charge was sufficient, they wouldn't have had the question. I'm sorry for going over my time.
No problem. Thank you. Mancusi versus Avalon Bay Communities.
Good afternoon, Your Honors. Paul Hawansky for the respondents. There's really no reason to disturb the lower court's decision, and from my understanding, appellant is only challenging language in the decision stating that the plaintiff's negligence can be imputed on the employer in this case. First off, Labor Law 240 claim is still in this case. The court denied our cross motion for summary judgment, and appellant concedes that negligence of the worker can be imputed to the employer for contractual indemnification purposes where 240 is in play. More to the point, the decision in the court below did not rule that imputing plaintiff's negligence to the employer was the only way to attribute negligence to SJ Electric. Respondents made a detailed showing of active negligence on the part of SJ Electric from a supervisory standpoint. Those are laid out in point 4 of our brief. So I would submit that this appeal is actually an application to clarify dicta within the lower court order, which counsel wanted, could have, and should have been done with the trial court judge, but the end result is the same. There are issues of fact as to SJ Negligence's own negligence, and I don't believe appellant is even disputing that point. Thank you.
Thank you. Matter of Ashanti versus New York City Conflicts of Interest Board.
Good afternoon, Your Honors. Carl Ashanti, appellant pro se. This matter involves various forms of overreach by the Conflict of Interest Board in making various findings of violations of the Conflict of Interest law against me. The most glaring of which is overreach by the participation of a former corporation counsel by the name of Jeffrey Freelander, who served with the law department for 45 years, virtually the entirety of his legal career prior to participation with the Conflict of Interest Board, in being part of the panel that found against me, and he was corporation counsel on more than one occasion. And so that is the same body that is represented the city, of course, here, and also in the matter itself. There was also various forms of overreach concerning the legal standard that was applied by the board concerning 2604B3. They applied a standard of intent where that provision has no such standard as part of its plain language. And even if you were to accept that it was a proper application of intent concerning that charge, the board ignored the evidence of its own witness in stating in sworn testimony that he did not find that I had intended to gain any benefit based upon a conversation that we had had concerning the small claims matter, concerning the dispute that my wife had with the health insurance company, Metro Plus. Additionally, there was overreach by the board in its imposition of a $5,000 fine for violation of 2604B7, where the myriad of cases based upon that similar charge had a fraction of the same amount of a fine, even after a change to the law that allowed for an increased fine. Additionally, the same overreach applies to a fine of $2,000 for violation of 2604B2 with respect to the use of letterhead. The cases that are cited in my briefing show that the other examples of similar fines are $200 and less.
Were the other litigants in those cases attorneys?
Not in, I believe, no.
None.
We're not.
So do you not appreciate that an attorney in our state is held to a higher ethical standard than those without a license to practice law?
Well, two things on that, Your Honor. One is that I don't practice in the area of law whatsoever.
You went to law, counsel, please.
I'm just pointing out that fact.
You went to law school, you graduated, and you studied for the bar exam, and I presumed passed since you are practicing in the state of New York.
I am, Your Honor, but
Okay.
again,
So you understand better than your average Joe, no disparity to any Joes in the audience, right? That there is a higher standard that we expect of attorneys.
yes, Your Honor, that's correct. But
Okay.
there are two things on that. One is the defendant involved in the small claims matter that underlies this issue was Metro Plus, which by any account, and you ask anyone, including attorneys, if they know what connection or who that subsidiary of Metro Plus is subsidiary of, they would not know, and I did not know.
Look, the bottom line is you knew you could not represent your wife without permission from your agency.
I did not know that.
You did not know that?
But I had a conversation after the fact with another.
Seriously, you work for the city and you believe that it was okay for you to take cases on the side without approval?
No, this is not a case on the side. I accepted no money.
It doesn't matter. Even if you appear pro bono, right? You don't accept a fee, but you appear on behalf of another. You're representing somebody, and you work for the city.
Yes.
So you were required to get permission to do that.
My point is, there was a discussion that we had in past examples that I had been involved in working for the city. There had been the use of conflict counsel in such situations. So the discussion that was had was, my suggestion, is it possibility that we could have a conflict counsel be used in this instance? And so there's an argument by the CIB that there were warnings that were given and so on and so forth, but there was no such warning. There was a discussion that would it be applicable here to have conflict counsel? And rather than that question ever being answered, the charges came down instead. And so
I believe my colleague had a question, Judge Moulton.
Well, I was going to ask about how you knew to file the notice of claim against Metro Plus, if you were in the dark that it was not related, it wasn't a city agency.
No, at the beginning of the case, the notice of claim was not, in the normal course of things, a notice of claim is filed before suit, correct? Here,
You don't have to do it unless it's a city entity, right, or a governmental entity.
but the point being, in the normal course of events, a notice of claim is usually filed before a lawsuit. Here, I filed the notice of claim after, because I did not know at the beginning. That's actually proof of the opposite of what it's being used for. I did not know initially, and so I'm not saying that I never knew. I'm saying I did know at some point, and that's when we had the discussion regarding conflict counsel. But at the beginning, I did not know, because as a corporation counsel attorney, I would have filed a notice of claim if I felt that I was allowed to. And I did not, there was no effort to, there was no surreptitious, did not use a pseudonym. There was no point in time at which I hid any of that, my identity, my relationship with my wife, or anything, because for the very fact that I did not believe it was wrong initially. And then when I learned, I had this discussion. I said, well, then, can it be the use of conflict counsel? And the point being here.
All right, you're going to have time on rebuttal because we've gone over your argument time, okay? You may proceed, sir.
Good afternoon, Your Honors. Philip Young here on behalf of Respondent, the Conflicts of Interest Board. So first, just a quick clarification on the facts here. Ashanti claims that no warnings were given to him regarding the conflict of interest. Warnings were given to him twice. First, in an April 2017 phone call with a law department attorney who informed him that he was representing Metro Plus because Metro Plus was an agency, a subsidiary of HC, which is part of the city. And then again, he received a warning in June 2017 when he had another conversation, this time in person, with this law department attorney who was representing Metro Plus, where the attorney informed him about his concerns about the conflict of interest. He was informed in April. He continued representing his wife for months after that. He was informed in June. He continued representing his wife for 3 weeks after that. Finally, he did file a letter withdrawing as counsel for his wife. He did that on city letterhead that included the corporation counsel's name and his work address. In that letter, he wrote that his wife's claim against the city of New York was highly meritorious. The board's decision to impose penalties worth a total of $8,500, each of which individually were far below the maximum $25,000 penalty, were well within the board's discretion and were not shocking to one's sense of fairness. And there was substantial evidence supporting the board's conclusion that Ashanti used his position, invoked his position in order to obtain special treatment based upon his invoking that position in his conversation with a Metro Plus employee regarding his wife's compensation.
Could you tell us how much the amount in controversy underlying this whole tragedy of errors?
Your Honor, I believe it was somewhere just under $2,000. I think that the precise dollar amount varies depending on how many weeks of vacation time were available to his wife. There are no further questions. The Conflicts of Interest Board asks that the court confirm the board's determination. Thank you, Your Honors.
Counsel, you've got 2 minutes.
Thank you. So the record will show that there was no warning. There were discussions that were had, and again, there's a mischaracterization of the nature of those discussions. The testimony will stand for itself. The Metro Plus's own witness, the only witness that they put forth, stated specifically that he did not feel that I intended to gain any benefit, and that was also my testimony. And that was the only evidence or testimony that was introduced on that subject. It is my position that intent is not a proper application, so it should be vacated on that basis. But if it were, then the only evidence that was supported is the adverse finding. And there should be, as well, there's no consideration of mitigation based upon the fact that I lost my employment. I was terminated on this basis, specifically stating in sworn testimony by a law department executive, and there was no consideration of that by the Conflict of Interest Board in assessing this nearly $10,000 fine against me for a $1,700 controversy in small claims court. And that was specifically excessive, Your Honor, so I would find that those facts really militate against the Conflict of Interest Board's order.
Thank you. Coster, Brady, and Nagler versus Paul Kalan. You may proceed.
Thank you, Your Honor. Good afternoon, Your Honor. Seth Weinberg with Morrow Lilling the party, excuse me, for the appellants. And I'd like to begin with the court's findings as to public policy in this case. And what the court held was that it is a violation of public policy for a law firm to collect on a contingency fee generated by a partner while still at the firm. But it is not void for public policy for the partner after he leaves to take contingency fees on cases he did not work on.
It's a one-way, according to the Supreme Court, it's a one-way street, not a two-way street.
Exactly, and what's interesting about it, Your Honor, is...
Well, let me get to the heart of this. I mean, the whole point of this was that the Supreme Court struck it down, or at least found in the defendant's favor based on Rule 1.5, right?
Correct. And more specifically,
1.5 really is the 1.5 is really the linchpin of the decision, because without it, then I guess the argument could be that there's a factual issue going both ways. Is there an oral agreement? Does that oral agreement provide for fee sharing, right?
Right. And more specifically, did the trial court rely on 1.5G? But if the court went to the next paragraph of 1.5H, says 1.5G does not apply to retirement and separation agreements, which this was.
Right.
So to say it's a one-way, I don't, quite frankly, know how it could have ever been a one-way street, but the terms of the rules on its face.
Well, if this is let to stand, it's going to really it's a game changer with respect to what's out there. If Supreme Court's decision, the way it wrote it up, right? I mean, it changes the dynamic of all the partnerships.
It
Well,
basically,
based on contingency fees.
right, it almost makes it pointless to be in a partnership because your other partners can't share in the benefit. You can leave.
Well, and in this case too, there's in the record here, the fact of the matter is the defendant had this case that you're looking to share the fee on while he was still there. I mean, he was doing work at the firm, right? For the
What he
for
told
the
his
Fleming individual, for Mr. Fleming.
Correct. What he told his partners was, I'm going to get essentially a $20,000 contingency fee when it settles, and it's going to settle because this is
based on a consulting fee.
On a consulting, exactly, air quotes, Your Honors. And then after he leaves the firm, and more importantly, after he starts telling the other firm he's getting involved with,
He got put
can't
on
talk about this while I'm still here.
He got put on as a retainer. He got put on the retainer, and then they settled it for $9.5 million. And if 75% goes to your guys, that's a big chunk of money, right?
It's a big chunk of money, and on top of that, when you look at it from the Costello case, this former partner was happy to take the check on that case that he didn't work on.
Right.
And I was just thrilled, he says, because the firm was having problems, so I didn't say anything about whether this was the agreement we had or not. I was just thrilled to get money.
Right.
And according to the Supreme Court, that's okay.
That's okay.
But it doesn't work both ways. So unless the court has any questions on the other issues, I'll happy to spend the rest of my time on rebuttal.
Thank you.
Thank you, Your Honors.
Good afternoon.
Good afternoon.
Robert on behalf of the respondents. The trial court in its decision also deals with the issue of the statute of frauds, and I'd like to start with that. The trial court correctly held that contracts that have indefinite durations are considered incapable of performance within a year.
So you get to the statute of frauds. Let's just say then, if we put aside 1.5, because I think the thrust of the Supreme Court's decision was the 1.5 rule, Rule 1.5, right?
Well,
so without that, your next argument would be the statute of frauds, right?
Correct. And under the statute of, and I'm going to come back to the 1.5 because the court also talks about the public policy considerations in 5.6.
It's a real big chunk of his decision, the 1.5.
And that's because the appellants in their original moving papers are the ones who focus on 1.5, and that's why the court spent its time on it.
Right.
But clearly, this agreement, as the court held below, there was no written agreement governing Mr. Callan's relationship with the firm as related to contingency fee cases. And it was clear that, quote, that complaint paragraph 36, which is the operative alleged oral agreement, by its terms was to last for as long as the firm remained in business. And quoting
Counsel, isn't it true that the standard is whether it could have been performed within 1 year, not whether it was performed in 1 year?
That is correct, Your Honor, and this contract is incapable of being performed within 1 year because the terms are all indefinite. It includes not just this partner, but any potential future partner at any time in the future. And if you take it to its logical extension, one could potentially argue, well, wait a minute, what if all the partners leave in a year? Isn't it then capable of performance? And the answer is no, because at that point, this alleged oral agreement would have been terminated. And in our brief, we explained that termination is not the same thing as performance. So at the end of the day here, this contract was incapable of performance.
How do you
No, that's not right, counsel, because it's completely performed. It's just the partnership ends. And so the contract is performed 100% and the partnership ends, meaning it could be performed 100% with no breach and nothing else going on within 1 year.
But, Your Honor,
That's the way every contract is with respect to the statute of frauds. If the contract can be fully performed by either the partnership breaking up or termination or any other matter, we're not talking about termination of the contract. We're talking about termination of the law firm, which would then, the contract would be fully performed.
No, Your Honor, because if you look at,
I think you and I disagree on that then, because that's really how my understanding of how the statute works.
I respectfully slightly disagree with that, Your Honor, to the point that
Fair enough. So then, all right, let's assume that we don't agree with you that it couldn't be performed within a year. Then what's next?
then, as we have here, because we have an indefinite duration, we know that it's incapable of performance, and then it falls outside the statute of
Let's
frauds.
assume it's in the statute. What else do you have?
We have the issue here, the trial court's decision was not just focused on 1.5, but it's really a 5.6 issue, which has to do with nothing is more important than the client's right to choose counsel they want, and this constitutes an impermissible restriction on the practice of law. When you have a situation where a departing partner is going to have to remit 78.75% of a contingency fee on a matter in which there's no
How does that
determination.
affect his ability, how does that put a restriction on his ability to get clients? I mean, he just means he's just got to give his former firm a piece of the pie. It doesn't affect his ability to get clients and represent clients.
It does, Your Honor, because the way we analyze this is a financial disincentive. Lawyers who would have to remit such a
Well, then that's where the partnership agreement is, where you got to put it down in the partnership agreement to make it clear, right?
But there's case law in New York that comes from Cohn and the progeny that comes from that even a partnership agreement, there's the Silverberg case from the second department, where an 80% remittance back without any consideration.
There's a little wrinkle in this case, though, unless I read the record wrong. Your client was already engaged in some way with Mr. Fleming's representation while still at the firm, before he left, right? So there's a little wrinkle. I mean, I got all those cases, and that's the beauty of the law. There's always a little wrinkle to something, right? So all the cases that I looked at, you didn't have that kind of slight wrinkle here.
But, Your Honor, even assuming for a minute, and we will disagree with the fact is that Mr. Cowan was working as a consultant toward the end of 2014, but assuming for purposes of your question that the firm had actually retained the client, it would still be a violation of 5.6 because it would restrict Mr. Callan's ability to move because he would still be forced to remit almost 80% of the fee back to the firm without any location, any indication of what the amount of work that was needed to be done.
But counsel, isn't that how basically every contingency fee firm works? That's how they all work.
No, Your Honor.
When you leave, I mean, we see a bunch of them up here in the first department. When you leave, you say, whatever I get 20, 52% of whatever the settlement is of everything that's in the hopper. That's not an unusual agreement.
If I may, Your Honor, even though it's red to answer your question, you used a great phrase, in the hopper. What the analysis would be is what's the quantum merit value of the case at the time that the partner left? That's what Thalen and the unfinished business doctrine cases tell us about contingency fee matters.
Now, that's not the way it works, though. That's not the way the firms do it. They wait until the settlement, and then they send everybody their check. That's the way it goes. And the question of whether or not the case is in the hopper is not up. Maybe the case wasn't in the hopper. Maybe your client took it afterwards. That's not the issue. The issue is whether there's something wrong with that agreement.
And, Your Honor, under the oral agreement that's alleged, we submit that it would violate attorney mobility, the client's right to choose, because it's a significant financial disincentive that a lawyer would have to remit close to 80% of a fee unearned for future work done on a matter. Thank you for the court's time.
That's a very interesting argument. Come on up.
Thank you, Your Honors. I think most of my colleagues' arguments can really be addressed by the wrinkle, as Judge Oing put it, which, quite frankly, it's not just Judge Oing who saw this wrinkle, it's a prior panel of this court who found there is evidence that this other attorney tried to woo a client of his firm. And not one of the cases that my adversaries rely upon deal with a partner who's effectively breaching the fiduciary duty to his partners while at the firm to then take the case away later. These are all cases involving either two separate plaintiffs' firms at the time the fee-sharing agreement came into being, or firms that are dissolved, and now we're talking about how do we calculate their assets at the time of bankruptcy to protect the creditors, the lawyers who will now be practicing at other places and firms. This is not an attorney who created a fact pattern, quite frankly. He created this fact pattern This fact pattern does not fit within those rubrics. There is no restriction that was created on anyone by himself, because he could have done this all on the up and up. And even if he didn't want to give up 78% of the fee.
Well, counsel, let me just go to a different issue. Where's your contracts, acknowledged by the party to be charged?
I'm sorry, Your Honor.
Where's the contract acknowledged by the party to be charged?
So, under Fox at the Court of Appeals,
No, I just want to know. You say there's emails. Does he acknowledge in those emails that he is a party to that contract?
he acknowledged no, he did not respond to those emails.
So clearly that contract isn't established as a matter of law, because the party to be charged always has to acknowledge that they're, or in an oral contract particularly, or one that's set with a number of documents that doesn't say contract on top. That party to be charged has to evidence you might be able to prove it by deposition testimony or testimony, but there's no document in which he acknowledges it. Am I right?
The only document would be the Regan strike agreement. That's the document he
But
signed.
that's not for him. That's for the other guy. That's 15 years early for the other guy. I'm not saying that that's not evidence of the contract, but it's not, as a matter of law, evidence of the contract, right?
Well, where I would differ with that, Your Honor, is what Fox says is we can look at several documents. So standing
Tell me
alone,
any of the documents that you want to look at, where does he specifically acknowledge that he is a party to that contract?
Would you say the acceptance of the Costello
No,
settlement
I'm
amount
sorry.
would be sufficient?
yeah, he accepted the money and he did not refute that this is the calculation. And the email said, per our agreement, here is what you were entitled to. And he did not say anything to that.
I mean, but that's exactly what I'm saying to you. Is it enough not to object? If someone sends me money and I don't object, that doesn't necessarily mean that that's my contract. It might be you can prove it, but it's not as a matter of law that that's my contract.
Well, and why I keep going back to Fox, Your Honor, I'm not trying
And
to...
I'm going to ask you to make your comment short.
Yes, is that you look at all of the documents, they don't all need to be signed, and it is all evidence taken in total.
Thank you.
Your Honors.
Sanchez D. Felix versus 500 East Fordham Road Corp. and 7-Eleven. You granted 4 minutes.
Thank you very much. I represent Defendant 7-Eleven Incorporated. We are the franchisor. Our franchisee is a DEM. Pursuant to the franchise agreement, which is a particular sort of agreement here, not an ordinary franchise agreement, a DEM has to either own or lease the property in which it's going to operate the franchise, which it did. It leased this premises from 590 East Fordham. They're saying that the motion for summary judgment is premature due to outstanding depositions. However, the court totally overlooked the fact that we put in the affidavit of Kevin Jennings, which is the person who would be deposed on behalf of 7-Eleven, and he confirms, referring to the franchise agreement, that 7-Eleven has no maintenance responsibilities for this property. And oddly enough, the president of 590 East Fordham Company also testifies, page 303, that 7-Eleven has no responsibilities under these leases, under this lease. So, pursuant to the administrative code, any sidewalk defects would only be, that cause injury would go to the landlord, the owner of the premises, absolutely not a party who is not even a party to the lease. The minimal opposition, again, the prematurity, this is unsubstantiated speculation because there's nothing that Mr. Jennings could say, absent committing perjury, that would somehow implicate 7-Eleven in this. And he just...
And so let me just ask you, counsel, and there was no affidavit in opposition by the party that, a DEM, saying, no, 7-Eleven came in every day and repaired the sidewalk, right? Nothing put in opposition to summary judgment.
Correct.
Zero, right?
Absolutely.
And they're saying they want to depose themselves, right? They want a deposition of the ADEM employee, right?
They want, right,
So they
a
know what
deposition of.
the ADEM employee's gonna say. They don't need to depose their own employee.
Correct.
Right?
Correct.
Good.
Absolutely. Thank you very much.
Good afternoon, and may it please the court. I represent defendant respondent ADEM Service Station, which is the tenant and franchisee at the lost location. Lower court's decision in denying 7-Eleven's motion as premature is very much consistent with this honorable court's tendency to deny such motions where party depositions and written discovery is incomplete.
But we deny them only where, it is obvious that there are issues that still need to be sorted out. And here, as my colleague just said, it's your own witness.
I'm a little confused by that, Your Honor. My witness has not testified yet, and neither has 7-Eleven's witness. I'm not saying that this is not the landlord's case. It absolutely looks like it is the landlord's case, and I myself will likely move for summary judgment at the conclusion of depositions. However, to make sure that I'm able to do so properly, I need a witness on behalf of 7-Eleven. They've submitted this affidavit from their market manager, Kevin Jennings, who apparently went to the property once every 2 months. It's very vague in terms of what he would do when he would go to the property.
Where in the franchise agreement, I'm sorry to cut you off, but where in the franchise agreement is there a provision that says the 7-Eleven Corporation is going to be responsible for maintaining something outside of the store? I couldn't find it.
Here's where the ambiguity lies, Your Honor. Firstly, it states that if an incident occurs in or at the store, now store is a defined term.
The public sidewalk is not the store. Yeah. We can all agree on that.
I would have to agree with you on that, Your Honor. However,
okay.
Store is, in fact, is a defined term in this case.
Yeah, but that sidewalk, the place where, unless I'm looking at the photograph, the place where the plaintiff tripped and fell is pretty far away from the store. It's not like right outside. I mean, arguably, if it was right out the store, maybe. But this was like further away. It's like past the gas pumps that she tripped and fell.
I would note that the franchise agreement, which again, upon information and belief, is drafted by 7-Eleven.
You signed it, but I understand that, but it's a document that's pretty clear on its face. I mean, you know, they drafted it, yeah. I mean, you know, your guy as the franchisee could have said, no, I don't like this. You know, they could have negotiated, but they didn't. He signed it. I mean, you know, it's not an adhesion contract, if that's what you're telling me, because he's getting a benefit out of it, because he's getting to use 7-Eleven's name and make money out, right? Presumably.
There's also some questions as to whether or not...
You didn't answer my question. Am I missing a provision in the franchise agreement that says 7-Eleven Corporation is on the hook?
Nothing that specific, but I would say that there are ambiguities, Your Honor, specifically the portion that states that...
Thank you. You thought I forgot the question, right?
There is nothing that specific, unfortunately. However, we would request the opportunity to depose a witness on behalf of 7-Eleven. I would also note...
On what? For what purpose would you need to depose that witness?
Not only the ambiguity with respect to the definition of the store, but whether or not it would constitute a landscaped portion of the store.
You gotta be kidding me. You just gotta be kidding me. This is the sidewalk by the bus stop. I don't get it. You've got a 7-Eleven store, a gas station, and then a sidewalk. Clearly, the store had nothing to do with this sidewalk.
It'd be a different case if you had a customer burning his lip on a coffee that was served by 7-Eleven, but that's not the case here.
I would just rest...
At least I'm not thinking that's the case here. I got the right case.
Listen, I'm not conceding that my client either had anything to do with it. We're the tenant. The lease agreement is very clear that it's the landlord's responsibility to take care of the sidewalk. However, we do feel that summary judgment is not justified at this point, where the existence of facts essential to oppose the motion might rest with 7-Eleven.
Again, that's what fact is it? The agreement says nothing about the sidewalk. So what fact do you think you're going to find by a deposition? Certainly you've argued we need to have our own deposition, which I really don't understand, because you know what your witness is going to say. And if the franchise agreement, if there's nothing in the franchise agreement that says that 7-Eleven has any responsibility for the public sidewalk, what fact are you looking for that you think is missing?
It's that definition of store. Exhibit A of the franchise agreement does does appear to
You know,
perhaps
I
define store.
hear what you're just saying, the definition of the store. You're asking the wrong person. Aren't you supposed to ask the landlord what the definition of the store is? Because it's the landlord's lease to your client. So it's their definition of store because, well, I got it.
All right.
I understand. However, we would, of course, request that the lower court's decision not be affirmed, especially where 7-Eleven has subsequently moved to re-argue. The lower court did reconsider the affidavit of Mr. Jennings, and even with that information, still chose to deny their motion for summary judgment at this juncture. Thank you for your time.
Thank you.
Okay, you have 1 minute.
I don't think I need it. Obviously, whatever happened on re-argument is to whore the record and not before this court. There's nothing in this record that shows that 7-Eleven had anything to do with the maintenance of the property, obviously even the sidewalk, and Carrie Wolf, the president of 590 East Fordham, he testified that if there were any citations, he would take care of it. He had his own managing corp, Bill Wolf Petroleum Corp, who inspects and reports to him anything that was reported, the landlord would take care of, and he himself out and out said, yes, 7-Eleven has nothing to do with it.
Thank you.
Thank you.
People v. Renee Garcia.
That's submitted.
Was that one? Was that submitted? Never mind. SL Globetrotter versus Savretta Capital.
Good afternoon, Your Honors. Christopher Bellew from Gibson Dunn on behalf of the appellants. Plaintiff's case and Justice Sherwood's opinion below turns on one word, and that one word is historic. And it's nowhere to be found in the relevant provision here, which is Section 5.4 of the share subscription agreements, which is the governing contract here in this case, not an investor presentation that Justice Sherwood focused on and that plaintiffs focus on. And there are three assumptions that Justice Sherwood made, all of which are fundamentally flawed, and any one of which would require reversal. So I want to go through each of them one by one. The first is that in order for Justice Sherwood to have been correct, the word, in the disclaimer, in the investor presentation, financial information had to have been a definition. And it is clear from the top of that page that it is a disclaimer. There is nothing in the disclaimer that defines the word financial information. All it says is the historic financial information respecting Global Blue contained in this presentation has been taken from or prepared based on the historic audited financial statements of Global Blue. In other words, all that says is this is a description of the historic financial information in this investor presentation, and it's been taken from audited statements. That is not a definition.
Counsel, aren't you seeking representations and warranties that essentially the seller is clairvoyant and knows what's going to happen in the future?
Well, no, I mean, that's what they bargained for. We bargained for this provision. It's a bespoke provision. It was put in there by sophisticated parties, commercial entities, and it's not for entirety, Your Honor. It's a SPAC transaction, and in a SPAC transaction, the SPAC sponsor goes out and finds PIPE investors. The PIPE investors make a commitment to buy shares at closing. So between the time they enter into the share subscription agreement, which was January, and the closing, which was August in this case, they agreed to make that commitment subject to the reps and warranties. And in that time period, what the PIPE investors are trying to determine is that they're going to get the same information as the public investors, in other words, the SPAC shareholders, at the time when the proxies filings are actually submitted or made public. And so it's not clairvoyant for all time. And in fact, Justice Sherwood focused on Section 6, I think it's G and H of the share subscription agreement. Those are risks post-closing that our clients take on if they take on the shares.
So, counsel, let me ask you this. The question is, the rep is whether the business and financial information with respect to Global would not be materially inconsistent with the description of the business and financial information in the proxy statement. And we both agree, correct, that business and financial statement information is not defined,
I agree with you on that,
right?
yeah.
So business and financial information could mean just the historic information. It could mean the historic information and the future prospects. And looking at the entirety of the agreement, seems like it could be either one of those, not just one. Your view is it includes both historic and future, and the plaintiff's view is it only includes the information that we gave you and not the projections. And since it's not defined, I don't know how we could dismiss this complaint. And in fact, I'll just tell you, just out of curiosity, I Googled what does business and financial information mean, and I got more than two different descriptions of it. One which did include future information or future projections, and one that didn't.
So that was going to be the third assumption I was going to say was wrong. The second, which I'll skip over, is that the investor presentation has to actually be incorporated into the share subscription agreement, which I don't think it is. But now to your question.
You're saying that condition precedent, which is that the business and financial information will be the same, wasn't met, which allows you to get out of the agreement. And I'm saying there's not universal agreement what business and financial information means.
Yeah, so Your Honor, to respond directly to that, if you look at 5F and you look at the whole sentence, it says, the description of the business and financial information of the target, meaning Global Blue, to be included in the proxy statement. So in the 600-page proxy statement, there's going to be a description of the business and financial information. And then it says, to be provided to the stockholders of Farpoint, that's the SPAC, in connection with the transaction, shall not be materially inconsistent with, this is important, the information included in the investor presentation. The information there is not...
No, I think it's with the description of the business and financial information in the proxy statement.
No.
So that is the difference. You think it means one thing, they think it means another thing. It's not defined in the agreement, and I don't know how we could dismiss a case
if I may
on that
keep
ground.
responding to your point, the information in the investor presentation is by definition a description of the business and financial information. It's saying...
Plus a disclaimer that everything that we're saying about the future may or may not come true. So if you're going to add that in, then you're dead in the water.
No, because if this disclaimer is incorporated, then 5F means nothing, because the disclaimer says twice, no representation express or implied as to the accuracy, they're making no representation as to the accuracy or completeness of the information contained in herein. If that's true, then 5F means nothing. And then you go to general principles.
It could mean that.
Okay, this is going to be a circular argument, and you'll have time on rebuttal.
You're right.
You may proceed.
Thank you. May it please the court, Gerson Zweifach for the respondents. I don't think Justice Sherwood made a mistake at all. It was a relevant provision to look at the investor deck, and here's why. It wasn't extraneous. It wasn't outside the four corners. This agreement said, it could have said, we'll make certain numbers. It didn't say that. It said that the business information, and then it says the financial information in the proxy and in the investor deck will not be inconsistent. As you point out, it's a very general term. It isn't given any real context. But what it's saying is, look at the presentation of financial information in that document. That's the baseline. And the baseline that Justice Sherwood looked at was a document, and I urge the court to look at it. It's 2067 in the record. It's the fourth volume. The second paragraph says, we have in here all kinds of projections and future-oriented information which you cannot count on. We can't even tell you that in the future we can make projections. The fifth paragraph, which they purported to cite in their brief, but they left out two words, the fifth paragraph says, it has a title, financial information. Those are the two words they left out of their reply brief when they purported to quote the relevant paragraph. That's an important title.
I'm sorry, counsel, then I'm probably going where you're going. After financial information, it says the historic financial information contained in this presentation.
Exactly. My point is simply, If you are reading all the words, as Justice Sherwood properly did, and you do when you're trying to construe a business contract, these parties pointed to the investor presentation and said, that's where you find context for the word financial information. And on that page, the second paragraph disclaims all the future-oriented stuff and says, don't rely on this. The fifth paragraph is entitled financial information, and it proceeds to flesh out what they mean by that. The historic numbers that are found in our audited statements. Those two pieces fit together. The second paragraph says, the future stuff, who knows? The fifth paragraph, entitled financial information, focuses exclusively on historic.
So
that's what Justice Sherwood was looking at. I'm sorry.
In your view, counsel, is that meant that you couldn't go back and re-audit all your financials for the last 5 years and have the proxy come up with different audited financials than the ones that you had disclosed?
In fact, what you're talking about is exactly what's in the relevant paragraph, because after the title, financial information, there are two sentences. The first one says, these historic numbers were developed under some European accounting convention. I don't even know what it is, but that's what it says. And the second sentence says, before these go into the U.S. proxy for U.S. shareholders, they're going to be audited under U.S. PCAOB standards. And so the representation isn't meaningless. The representation is basically saying, when the historic numbers get represented under U.S. standards, they will not be materially inconsistent. Now, these folks have not pointed to any material inconsistency. Are they different? Sure. They're actually a little better as they appear in the proxy. But the material inconsistency, they say, that they seize upon is the fact that there are no projections in the proxy. Because exactly what they said could happen in the investor presentation did happen, which is they ended up in a place where they couldn't make forward projections. But that's not part of financial information for purposes of the investor deck. And that's where the contract points you to understand what is meant by financial information. It's historic. So there's no inconsistency between a world in which the historic numbers are laid out and the deck warns, we may never be able to give you projections again, and a proxy which repeats under US standards the historic numbers. They're not materially inconsistent, but it says we can't give you future projections. That's exactly what the deck suggested. And Justice Sherwood also seized upon an important provision, 6G. And that's the provision that says, we are aware as subscribers of all the risks laid out in the investor desk. And we've had a chance to talk to lawyers and accountants and mumbo jumbo, and we accept them. That's essentially what it says. And one of the risks that's outlined in the deck is the risk that we are in a business where we may not be able to provide you future projections. So in other words, what Justice Sherwood found was all these provisions read together meant that in the context of this representation.
Well, he said that you've at least raised an issue of fact. Let's say you survive a pre-answer motion to dismiss, right?
I mean,
that's enough. That's enough at this point.
Well,
You did not rule as a matter of law that that's what your contract says.
I think, with respect, what he said was he rejected their legal argument.
About why, as a matter of law, the claim had to be dismissed.
Right, and he
right. Well, and we'll see who's right at the end of the day.
Okay. I guess I know I have a limited amount of time. I think what's important here is to remember this. This language in the investor deck that they would deride as, oh, that's just boilerplate. That's just fine print. Let's remember, the investor deck was done and known to these sophisticated parties, a hedge fund and a private equity firm, armed to the teeth with corporate lawyers, when they drafted this provision, this representation. And it's these parties that decided we're going to point to the investor presentation as the baseline of the representation. They're the ones who chose these words, and they're the ones who said the investor deck and the risks it identified are on them.
Thank you. You have 2 minutes.
Thank you. I just want to start off where Mr. Zweifach stopped. He is representing an entity that's controlled by Silver Lake, an $80 billion company. If they knew, if they wanted to put the word historic in there, they could have put the word historic in there. Our clients proposed this language. It was put in as a bespoke provision of the share subscription agreement. He keeps pointing to the disclaimer language. It actually is not consistent. He says, look at the second paragraph, then look at the fifth paragraph. If you look at the sixth paragraph, it talks about non-GAAP financial measures, which are all historic financials. He's saying, well, the paragraph before is everything that's contained is historic. Then what about the next paragraph? These aren't definitions. These are descriptors, disclaimers. He also points to, again, 6G and H, which I mentioned, which are about post-risk for my investors and my clients. One thing that Justice Sherwood and Mr. Zweifach don't even touch upon is provision 10G, which is an integration merger clause in here, which says this is the entire agreement. And Justice Sherwood didn't even address that in his opinion. Justice Sherwood wrote a 16-page opinion, and he doesn't quote 5F until page 13 to 14 of the decision. He completely sort of pushes it aside and says, well, there are all these disclaimers in an investor presentation. The investor presentation isn't the controlling document here. It is the share subscription agreement, which was negotiated, as Mr. Zweifach said, by sophisticated parties. If they wanted to put that word in here, they could have put the word historic in 5F. They didn't. As I was saying to Justice Scarpula, when you read the 5F in its entirety together, it talks about information in the investor presentation without qualification. And that's referring back to the description of the business and the financial information. That's important because the proxy is a 600-page document. So what it's saying is, look only at the description of the business and the financial information in the proxy. There's no limitation on what financial information is in the proxy. And then it's saying, look at all the information in the investor deck. That's all my clients got as part of the due diligence. And that includes not just the historic, but also the financial projections. Thank you, Your Honors.
Thank you. Cortez versus Terrence Cardinal Cook Health Center.
Good afternoon, Your Honors. May it please the court, Ben Bartolotta for the plaintiff appellant, estate of Juana Cortez. Ms. Cortez, at 79 years old, entered the respondent's nursing facility for the purpose of short-term rehabilitation following a hospital admission for a back injury. It was her intention to return home following the rehabilitation period. Upon admission, despite having some comorbidities, she was in stable condition. Lab work conducted on the date of admission showed that she had normal parameters of nutritional status. Over the course of the three-month admission period, Ms. Cortez sustained severe pressure ulcers. She lost approximately 20% of her body weight. She became severely malnourished,
Despite those facts, of course, Cardinal Cook provided the affidavit of Dr. Diamond. And Dr. Diamond said standard of care. So did he make out a prima facie case?
Well, Dr. Diamond's affidavits focused almost exclusively on plaintiff's pressure ulcer claims. And that's the problem with the lower court's decision, Your Honor. Despite all of these claims regarding malnutrition, mistreatment, failure to thrive being contained within plaintiff's bill of particulars and supplemental bill of particulars, the summary judgment motion focuses almost exclusively on the pressure ulcer claims. And that is
But he does talk about her nutrition somewhat.
Well, he talks about nutrition in the context of the pressure ulcers developing. And, Your Honors, the plaintiffs, of course, provided the affidavit, or affirmation rather, of Dr. Pearls, a Harvard-trained geriatrician, who very specifically discussed all the aspects of the nutrition and all the failures in providing proper nutrition to Ms. Cortez. They failed to provide food that she was able to eat because she found this to be very unpalatable. They had to accommodate her preferences. They didn't provide necessary assistance with eating. They didn't provide the supplements as ordered by the doctor. I mean, Dr. Pearls, the geriatrician that whose plaintiff provided in opposition, showed all of these deficits, and they were not sufficiently addressed. The lower court...
In fact, after Dr. Pearl submitted the affirmation where he talks about the understaffing issues, on reply, you didn't get the expert your expert to reply to that, right?
I'm sorry, I missed the question. Your Honor.
Dr. Pearls is your expert,
Yes.
right? After he put in, or she put in the affirmation about, a host of issues that the doctor raised in in the affirmation, there was no rebuttal of that from the other side, right? I mean, I didn't think that their doctor didn't put in a rebuttal affirmation, did he?
There was no rebuttal, that's correct, Your Honor.
All right, so it was left unchallenged in a sense.
That is right. But the main point is that really all of plaintiff's claims, besides the pressure ulcer claims, were unchallenged. It was admitted by the defendant in motion practice, the re-argument motion context that was made in the lower court, and even in the brief to this court, defendant admitted the focus was pressure ulcers. And that's why it was very surprising that the lower court dismissed all the claims except for the pressure ulcer claims. Speaking of re-argument, we attempted to avoid having to make this appeal. We moved for re-argument. Re-argument was denied. A cross motion, though, for change of venue was granted. That's the second appeal that is before this court. 6 years, almost 6 years after this case was commenced, a change of venue was granted based on an inadmissible admission agreement. There was no authentication of the purported signature of the decedent that's contained in that agreement. There's no certification of this agreement. And of course, there's no compliance with CPLR 511A, which states that such a motion has to be made within a reasonable time after commencement of the action.
And the contract with this venue provision was a contract prepared by the defendants here, correct?
That's correct, Your Honor. It was a venue selection clause contained in the arbitration agreement, which generally are binding. However, like I said, the time requirement,
I think also
must be complied with.
And also, it was signed at a point in time where, at least from the record here, the decedent was coming into the facility, and she wasn't in great shakes. I mean, she was stable, but there was sort of like, okay, sign this.
Potentially, and that's why they needed somebody to, besides authenticate the signature, certify that it was a legitimate agreement.
Right.
Thank you, Your Honor.
Thank you.
I'll wait for rebuttal.
Good afternoon, Your Honors. Judy Shamitzi from Wilson Alster for the respondent. I would like to start with this idea that the reason that we didn't submit a further expert affirmation on reply was because we concede that the plaintiff is right. So we don't. I'm not here to argue about the ulcers. I think that, obviously that those issues will be tried. But the defendant's point has always been that the plaintiff has failed in their expert affidavits to sufficiently rebut, and that's why it didn't submit a further expert. Because it wasn't necessary.
You're asking me to take that at face value, which is okay. I mean, you could have the affirmation. I mean, I just like to see a doctor's affirmation response saying, "Hey, look, you know what? He's wrong." But you're saying that.
I'm sorry, Your Honor, I'm not.
You're saying that we didn't put in a reply affirmation from your doctor because we didn't think it was necessary, right? I mean,
Correct.
Right. So, okay, I take that for what it's worth.
Okay.
I'm just saying that I'm no doctor, and
Well, that's right, but the idea is that there are standards which the expert must meet, which Your Honor are the experts in, right? So they have to respond to what we're saying, and they have to raise questions of fact.
Right.
Well, first you have to establish a prima facie case.
Correct, Your Honor.
How did you do that?
So now I will concede still here, I don't think there's anything wrong with that the focus of the motion was the ulcers, because we thought that was going to be the biggest piece. We lost on the biggest piece, but that's not to say that there were not other parts of the motion. So A1516 of the record, this is I'm citing to our expert's affidavit here, is the portion of the expert affidavit that discusses the fact that she was unable to take adequate nutrition. And this, by the way, ties.
It might have had something to do with the fact that the facility failed to give her an appetite.
Not true, Your Honor. On day one, on admission, the admission notes say that they took her food preferences. They took her food preferences 3 weeks later again. They added.
I don't think you allowed me to finish my statement, and I don't think you can read my mind.
My apologies, Your Honor.
That's not what I was talking about. She required medication in order to pique her appetite, and that was not given in time each morning. So she would wait for that pill. Meantime, her breakfast got cold every day. Her son testified that every day she was given cold food.
That's not what he said.
So I'm sorry, she lost 28 pounds in 3 months. A woman who weighed 110 pounds on entry. That is not normal. Ask any woman who tries to lose weight. That's not normal. That doesn't happen that readily. So there are issues here. And his saying, oh, the food, she just didn't like it. That's not an answer. That's not a medical answer.
It's not. Of course. Well, okay, so there are a couple of things. He said that her food was cold. Her food didn't arrive cold. She didn't eat any of her food, but they kept trying to get her to eat it, and it did with time get cold. By the way, she weighed 100 pounds on admission. I don't think it makes a huge amount of difference, but not 110. She was 101.4 on admission, and that is at page 751 of the record. So the reality is that they kept talking to her.
At A410 of the record, it said 110 pounds.
On the admission notes, on my client's...
All I can tell you is what I saw in the record, and I saw a notation of 110 pounds.
Your Honor, I mean, it's in the record multiple times. It's on 751. It's also on 950.
Counsel, motion for summary judgment, right? So conflicting facts. Maybe move on to another topic.
I'm sorry, Your Honor.
This is a motion for summary judgment.
It is.
So there are different contradictory statements in the record. I wouldn't quibble about 100 pounds right now. Why don't you move on in your argument?
There are notes in the chart, multiple notes, about getting her food preferences and changing the diet up to try and appease those. But the reality is she was lucid. She was always lucid. She was completely with it. So there's no claim here. The plaintiff has never made a claim that she was somehow incompetent to sign the admission agreement or incompetent to decide about whether or not she should be getting certain treatments, certain foods, the feeding tube, any of those things.
So talking about the admission statement, so why should, the change of venue 6 years later? I mean, usually you would move right away to change venue. I mean, to wait to go this far down to the motion for summary judgment being denied, and then when they make a motion to re-argue, you throw in a cross motion to change venue. What light bulb went off so late? Why?
Your Honor, I wasn't the one who prepared the motions, but the reality is, the contract didn't get stale because we waited on it, so we finished discovery in one point.
But there's cases from this department that says, if you wait
And
too long.
the statute says reasonable time. 6 years is not reasonable.
And which is why I absolutely...
We have case law that says 2 years is unreasonable.
Which is why it becomes, rather than a determination as a matter of law, it becomes a discretionary determination. And here, the court decided to exercise its discretion and transfer venue.
And why isn't it an abuse of discretion after 6 years?
Because it doesn't do anything to them that we waited.
Okay.
Thank you, Your Honors.
Your Honors, with regard to the claim that the lower court has discretion to grant the motion to transfer, that is not the law in this department. The case law is very clear that the CPLR 511A requirement is not discretionary. It is to be followed. Besides that, Your Honor, I think the only issue that was not addressed is what respondent brought up in the brief regarding punitive damages. Plaintiff seeks punitive damages under the public health law, under 2801D, not under negligence, but under the public health law. And we think that this case very clearly warrants at least plaintiff's ability to seek punitives at trial. Okay, the lower court did not dismiss punitive damages. And really, this issue should not be before this court. If this court decides to revive the claims that were dismissed, plaintiff's ability to seek punitives at trial should also be revived. Unless there are any other questions, I will rest on the brief.
Thank you.
Thank you very much, Your Honors.
People v. Bowie.
That's
Is submitted? Okay. Kogak versus Dargan.
Good afternoon, Your Honors. I am Tom Liotti for the appellant. I'd like to reserve 2 minutes, if I may. Thank you.
I've already given you the time that I was going to allot you, which is 5 and 2. So you already have that.
Thank you. I appreciate that, Judge. So in this beautiful courtroom that we have here, this is my first time arguing before this distinguished bench. So I have to say, this is probably the most beautiful courtroom in the land. It really is.
We agree with you wholeheartedly.
Fantastic, Judge. So I'm honored to be here today to argue on behalf of the appellant. My client should be entitled to summary judgment here. And the fact that Respondents' Counsel drafted 2 agreements, which in total basically said that my client was buying this business, Baba's Restaurant, for $375,000. And the Statute of Frauds basically says that there can't be any other understanding between them because that is the agreement that they had. And that was the written agreement. Any other understanding beyond that would violate the Statute of Frauds. 701 of the...
The problem that you have is that this purported oral contract flies completely in the face of 2 actual contracts, right?
Right, absolutely, Judge. That's the problem that we have in this case. So we have to go by the written contract itself. And the written contract says that it's a purchase price of $375,000. That was the total. And my client paid an additional over 37.1 months, $281,250, and he only owed $93,500 on top of the $75,000 that he paid as a down payment. And
according to the contract, the seller sold 75 shares of out of the 100 shares of the restaurant, correct?
Right, $375 for 100 shares of the restaurant.
No, you're not hearing what I'm saying.
Okay.
He sold 75 of the 100 shares. So 75% of the business, not 100% of the business.
I disagree with that, Judge. I think the contract itself spoke about $375,000 as a total sale. My client was not represented by counsel at the time. That was his understanding of the agreement. And if we allowed for the parole evidence rule here to take
Why?
place,
What's ambiguous about the contract that requires looking to parole evidence?
well, the client, my client, would testify about the disputed issues of fact here.
Counsel, that wasn't my question. My question was, what ambiguity exists in the written contract that would allow us to look at parole evidence?
Its ambiguity is on its face, Judge. It's unclear.
And if we disagree with that statement, explain to me where the ambiguity is.
The ambiguity is the fact that if there was going to be more money paid for the additional 25 shares, it should have been stated in the contract. That wasn't stated at all. So the total...
Perhaps because it wasn't part of the contract.
$375,000.
Perhaps because it wasn't part of the contract.
Well, no, I'm saying it was part of the contract. The $375,000 was for a total of 100 shares.
But that's not what the contract says, right? That's not what the contract says. The contract says, I'm selling you 75 shares, right?
I don't believe it says that, Judge. I believe the contract speaks for itself, and it says 100 shares.
Counsel, if that's the case, you're out of the ballpark, okay? The contract doesn't say 100 shares, it says 75 shares.
I disagree.
So I don't know what contract you're looking at.
Well, I'm looking at the fact that my client paid $281,000.
That's not the contract language.
I believe it is, Judge.
No. What your client paid is not what is written in the contract.
What's written in the contract also is that the respondent here was supposed to pay all of the taxes before February 1st, 2012.
And other than your client's statement that he did not do that, what documentary evidence is there in the record to support your client's position that the seller did not pay all his taxes?
It was never denied by him during the EBTs.
That was
And I
not
asked
my
him repeatedly
question.
about
He's,
that.
counsel, don't answer my question with a question. Where in the record is there documentary evidence that shows that the seller left a tax burden on this property? Where is the evidence?
The evidence is in the examination before trial, Judge.
No, that's not evidence, that's talk. Where are the documents that show that there was a tax bill due?
There are no documents in evidence, Judge.
Okay, we'll hear you on rebuttal after I hear from the other side.
Thank you, Judge.
Good afternoon, Your Honors. Nicole Meyer from Rosenfeld and Kaplan for the respondent. I think Your Honor hit the nail on the head here. You know, there's a contract, and you can find it right on record page 73. It's clear on its face that 75 of the 100 shares were being sold by the respondent for the purchase price of about $280,000. There's nothing in that contract that says it's the sale of the entire of all of the shares. There's never been an amendment to that contract. There's never been a supplemental stock transfer agreement, and there is testimony in the record that from respondent's brother that they spoke about if there was going to be a full sale, they would do evaluation later on, and that would be embodied in a later written contract. So what you have here is my client was still 25% owner following the sale of this agreement, and appellant's arguments here are inconsistent. On one hand, they're arguing that there's this parole evidence understanding that the entire restaurant was being sold, and on the other hand, they're claiming that that respondent's claims are barred by the Statute of Frauds. These are inconsistent positions, and none of them are supported by these clear documents, the stock transfer agreement and the employment agreement, both of which I point out have merger clauses. So, the fact that he's referring to, extra contractual understandings is just of no moment here.
Am I correct? I'm sorry. Am I correct that under the employment contract, should any party be dissatisfied with a 60-day notice, I believe it's 60 days, they would terminate that employment contract, correct?
Yes.
And was such a notice ever received by your client from the defendants here?
No, Your Honor. I think the record is clear that the appellant simply just stopped paying under the employment agreement. There was never any written termination here. And so...
And am I correct that it's been 9 years since the defendants have paid over any portion of the 25% due to your client of profits?
No profits have ever been...
Ever?
No, not since 2012 of any distributions or profits.
Right, so 9 years.
Right, yeah, sorry.
Okay, all right. Anything else?
No, I think unless you have any other questions, I'd like to submit on the papers and yields.
Thank you.
Thank you.
Okay, counsel, you have 2 minutes.
Judge, if there was going to be 25 shares that would be reserved here, why wasn't it in writing? It wasn't in writing because the attorney left it out, because the understanding...
It was in writing. He only sold 75 shares out of 100. That leaves 25.
If he wanted to buy the additional 25 shares, where was that in the contract, Judge? It was not in the contract at all.
Counsel, you seem to be arguing against yourself. I'm not sure what side you're arguing.
I'm arguing my side, Judge.
Okay.
So I'm trying to say to you, if it was for the 25 extra shares that my client was purchasing, where was that in the contract? It
No,
was
no,
not in
the contract doesn't talk about any sale. That's the whole point. The contract only talks about the 75 shares. You're adding in parole evidence, another 25 shares, which just
If the
isn't in the
additional
contract.
25 shares were to be sold,
That's
subsequent
that's
to-
in your client's head. It's not in the contract, right? The thing we have is a contract for 75 shares and an employment agreement. Now, what you're saying is that employment agreement really wasn't an employment agreement, but it says employment agreement, looks like an employment agreement. We have to read it as an employment agreement. The idea that your client was going to buy the extra 25 shares, that's not in any of the documents. It's only in your client's head, right?
Right, exactly.
So what else
But
is there
what
to
I'm
say?
saying to you, Judge, if the additional 25 shares were to be sold subsequent to the payout on this, that should have been in writing, and it violates the
maybe
statute
that's
of
just
frauds
your
because it
client's
wasn't in the
view.
contract.
Right, but maybe that's your
So
client's
that,
view and not the other.
that's kind of up in the air as to the price for the additional 25 shares, Judge.
Okay,
That's what I'm saying.
thank you so much.
Thank you.
McKern versus Estel Development Company. Am I saying that name right?
McEachern? I would defer to Justice Moulton on that.
All right, you may proceed.
May it please the court, my name is Scott Singer. I represent the plaintiff's appellants in this matter. The court may sense that there's a deja vu element to this appeal, and there's a reason for that, because over the last 2 years, there have been at least 3 cases reaching this court on very similar facts. In Ferguson against Durst, the plaintiff was ascending to an elevated work platform. He stepped on an inverted paint bucket that collapsed. In Portillo, also cited in my reply brief, it was an 18-inch bucket that overturned. And in Valdez against the city of New York, it was an inverted milk crate. Justice Moulton was on the Ferguson case. Valdez against the city, Justice Oing was on that one, so you're familiar with.
This is an oil barrel, right? This is an oil barrel.
It's an oil drum. It's
oil drum. It's big.
It's big.
It's big.
But it's the same idea. And the holding in Ferguson is applicable here.
What's next? You're going to get a silo? Well, we're going to get a silo as the next one. It seems like every progressively gets bigger.
It'll get bigger.
Doesn't anybody have a ladder?
A ladder anymore?
What happened to the ladders?
Well, there weren't any ladders. That was the problem.
Yeah, well.
So the holding of the Ferguson case, because, quote, because no safety devices were available to plaintiff to access the platform, as a matter of law, plaintiff's attempt to use the inverted bucket cannot be the sole proximate cause of his accident. And this applies here. There was absolutely no proof whatsoever that there were ladders available to him, not on the site, not anywhere. The one point that was referred to in the defendant's brief is, well, they built temporary ladders, but they built them, but they were pulled up as a matter of practice, and there was no evidence that there were any temporary ladders on the interior of this room. So there was nothing he could use. He stepped on the oil drum collapsed, and under all of those cases, plaintiff is entitled to summary judgment. There was no questions of fact. There was no basis for denial of plaintiff's motion.
What's your response to the argument that your guy should have gone and got a ladder?
There weren't any ladders to get. Okay. In cases like in Montgomery, there were ladders available. You know, you could have gotten, or even if.
No, but the implication is that your guy should have done more than just step on the oil drum. He should have just gone and looked for a ladder. What's your response to that?
If there's nothing available for him to use, and there was no a procedure for him to obtain a ladder, and there was none here, then he can't possibly be the sole proximate cause of the accident. Under all of those cases, it was addressed specifically in the Valdez case, the sole proximate cause defense. Not applicable here. Those cases, including the Court of Appeals cases in Montgomery and a whole line of cases, there were always cases where they said you could have gotten the ladder. Or all you had to do was make a call. None of that was applicable. There was no proof at all that he could have gotten a ladder. There was no ladder there, and under those cases, he's entitled to summary judgment. For the rest,
Are you saying as against EDC, or
as
you're
against,
saying against both EDC and Tishman, or just Tishman?
we believe he's entitled to against both. I did brief the issue of EDCs.
Isn't there an issue of fact as to whether there are two conflicting documents about whether EDC was an owner?
Yeah, there was some conflict,
Okay,
but
so
I would say yes.
But you're totally with the Tishman part, and you're arguing there was conflict, but you want us to grant EDC summary judgment against EDC too?
Well, he's certainly entitled against, maybe question of fact against EDC, but
Okay.
certainly against Tishman. Thank you for pointing that out, Your Honor. Yeah.
Thank you.
Good afternoon, Your Honor. Stephanie Tebbett for the defendant respondents. I would like to distinguish some important facts that the appellant has left out about those cases that he's trying to liken to the facts herein. In Ferguson, the plaintiff was actually instructed by his foreman to not use a different stairway, but to use that inverted bucket instead in order to access his means and method of access to where he was working. The foreman also testified that it was a commonplace practice for the workers to use that bucket to go up and down. In the facts herein, there is no evidence that that oil drum was used as a makeshift staircase or a makeshift
So you're trying
ladder.
to suggest then that just leads to what I had asked Mr. Singer. Are you trying to suggest that was a burden that the plaintiff had to go and look for a ladder? That's what you seem to be suggesting, right? That he shouldn't have used the drum. He should oil drum.
Mm-hmm.
He should have done something.
I understand that question, not so much as there's a burden for the plaintiff, but there's no evidence that there was no ladder. The plaintiff is trying to say, the appellant is saying that there was no ladder for him to use.
Yeah,
but had he looked at the instruction from his foreman and seen that there was no ladder, and in fact, the Tishman witness did testify that there
Well, the
had been a
foreman
ladder.
gave him the job. The foreman knew what he was being asked to do, to install these two ladders into a crevice that was 4 feet off the ground. He knew that.
Correct.
So.
Correct, and it's the
If I am told to go do X, and I am detailed exactly what I'm supposed to do, adhere one ladder to the outside, one on the inside.
Correct.
Obviously, there's no ladder there then.
Correct. The plaintiff's job was to install the permanent ladders, therefore there couldn't have been a temporary
Right, so it was
ladder
the
in place
foreman's
where he
job
was.
to make sure he could get in there safely.
And there was no specific instruction from the foreman for him not
Yeah,
I guess that's
no
where
evidence there was no ladder had he, it was his foreman's responsibility to provide that ladder.
That's exactly right. It was. And did the foreman say, sure, I gave him, because the only way that you can get an issue of fact on sole proximate clause is if the foreman said, here's a ladder, and he said, no, I'm not using your ladder, I'm going to use the barrel. Is there any testimony like that?
The plaintiff did not testify that his foreman specifically instructed him, however,
your burden.
yes, our witness did say that there.
Where is your testimony that the foreman said, here's a safety device that could help you do this, and your client and the plaintiff said, no, I'm not using it?
Well, in response to that, I would like to point out that the plaintiff testified when he saw the barrel there, he knew it wasn't a safe measure to do, that he aware that there should have been a different measure.
Doesn't matter. It doesn't relieve you of your burden.
Right.
First, you have to prove that you met your burden. So where is the proof that you met your burden of giving him an adequate safety device?
There is no evidence that there was not an adequate safety device provided.
Except that you have to show that there was.
So-
And there is no evidence that you provided a safety device.
So, counsel, I'm listening to the argument here. For me to accept what you're pitching would be to go away from your non-delegable duty under 240. Because if you're trying to convince us or convince me that, you know, he should have known better and, you know, you look in it, that would be sort of shifting 240's non-delegable duty from the owner or GC to the plaintiff now, saying that the plaintiff should be aware of what the job entails and should have known better.
Well, the foreman did instruct the plaintiff what his job entailed of installing the permanent staircase.
I got that.
And his foreman did give those instructions, and they.
I got that.
Tell me where the foreman said, there's a ladder that you can use so you don't fall down into that pit.
Or better
Where
yet.
is that?
Or better yet, don't use the oil drum.
Boylan, the testimony of the Tishman witness, did say that there was a ladder in place in that room that had been there for trades to access that room, and that temporary ladder would only not be there because they're installing a permanent one in its place. So,
Counsel, that doesn't help you. That hurts you. Because they removed the ladder, the temporary ladder, so that a permanent one could be put in place without providing a safety device for the worker who had to do that job to get into the pit.
Your Honor, we respectfully submit that there was a temporary ladder. There had been a temporary ladder that was used in place, and his foreman, it's the, when the foreman gave the instructions, he was never instructed to use that oil drum barrel. He was never told to use that as an improper safety device.
Thank you.
I really want to be quick. I know it's been a very long afternoon. I don't want to prolong it. As Justice Manzanet was pointing out, this opening was only 4 feet high. The foreman walked them over there, and he said, "This is the ladder." He clearly looked at in the room, and he was aware of the circumstance there. They were just following his instructions. In other words, the
What you just said sounded like there was a ladder in the pit.
There was no ladder in there.
Okay.
And incidentally, you know, this in the briefs also, they misquote what Boylan said. Boylan was asked, he's the project manager for Tishman, "Are you aware if any temporary means of access into the room was provided?" "I'm not aware." He didn't. There was no proof at all that there was a ladder in there. If there was a ladder at one time, it certainly wasn't there at the time of the accident.
But let me just, and there's no testimony from him that he actually ever gave the plaintiff, I mean, he knew that there was a drop, there's no doubt about it, because he asked him to build the ladder to fix the drop. There's no testimony anywhere from anyone that he actually gave a safety device to the plaintiff to transverse that drop, correct?
That's correct. There's no testimony as to that at all.
Thank you.
Thank you. Stand adjourned.
Thank you all.